Good afternoon, everyone. My name is Hadar Harris, and I'm the Executive Director of the Center for Human Rights and Humanitarian Law, and we want to welcome all of you to today's event, which is part of International Week, a whole series of events that are taking place this week, although at WCL maybe every week feels like International Week, to highlight and to focus attention on many of the programs, projects, centers, and academic initiatives in the field of international law. The Center for Human Rights and Humanitarian Law is very proud today to sponsor a conversation with Professor Juan Mendez. I will introduce Professor Mendez in a moment, although he certainly is someone who needs very little introduction. Before I do that, I want to draw to your attention things outside of the scope of International Week, a few upcoming events where there are flyers available outside on the table, but a few things to just draw to your specific attention, events that are coming up. On Thursday, November 3rd, next Thursday, we'll be having a talk in collaboration with the Women in the Law program focused on human rights and migrant workers' rights and redress in Indonesia. A very important issue for those of you who are focused on migration, on trafficking, on other issues of migration and human rights. I would encourage you to come. The person who is speaking, Anis Hidayah, is a recipient of the 2011 Human Rights Watch Alison DeForge Award. And she serves as the Executive Director of Migrant Care, an NGO based in Jakarta. So we're fortunate to have her here to speak with us next Thursday. Lunch, of course, will be served. On Monday, November 7th, at 4 o'clock in the student lounges, we will be hosting a well-known journalist and author on Haiti, as well as a researcher for human rights, who are talking about ethics in research and documentation in post-earthquake Haiti. It's a very important issue, and for those of you who've participated in some of our skills development seminars, it's something that has come up in terms of what are the ethics involved in documentation and research and interaction with survivors, especially in a post-conflict and post-natural disaster traumatic context. You kind of have everything in Haiti, so I would encourage you to join us at 4 o'clock on Monday, November 7th. On Wednesday, November 9th, we're going to keep you very busy that week. We have our third installment of Munching on Human Rights, giving you a little taste of human rights over lunch. And in this case, we'll be having an introduction to international humanitarian law with our own Professor Bob Goldman, who, among other things, was the first UN independent expert on human rights and terrorism, is a very well-known practitioner and academic, and teaches our humanitarian law courses here at WCL. Finally, for those of you who might be looking for a summer job, not that anybody in this room would actually do that, we are having something that's sponsored by the Office of Career and Professional Development, as well as organized by the Center's Student Advisory Board, something that we do each year called Cool Human Rights Work I Did on My Summer Vacation. It is stories from your peers about the work that they did last summer, the cool stuff that they did, the not so cool stuff that happened to them while they were doing that work, how they found their jobs, how they funded their jobs, and recommendations for how you might do the same. So that's on Wednesday, November 16th at 1 o'clock in room 101. That's just a little taste. For those of you who are not on the center's listserv, you should sign up, and there are sign-up sheets outside. And we will be, in an ongoing attempt to evaluate some of the center's work, you will be receiving evaluation forms at your very chair, which we encourage you please to fill out so that we can continue to look at the work that we're doing in events like today to improve on them. All of that said, did I give you enough time? Yes. See, that was good. I told you that I would give you some time to eat your pizza. So, not only is Professor Juan Mendez a esteemed academic practitioner, currently the UN Special Rapporteur on Torture, he eats pizza like the rest of us. It is my privilege and real honor to have worked more and more closely with Professor Mendez over the last couple of years. He was a human rights attorney in Argentina in the early 1970s when, because of the work he was doing, he was arrested and detained by Argentine security forces. He became one of Amnesty International's first prisoners of conscience in Argentina and was released in 1977 when he came to the United States. He's going to tell you more about this story, but just to give you a small introduction. He helped to set up Human Rights Watch. He set up America's Watch, which was one of the first arms of it, became their general counsel, then became, not in a, you'll tell the linear part of this, but among his many honors and accolades, he was an elected member of the InterAmerican Commission on Human Rights, its president, was the president of the International Center on Transitional Justice, and is still their president emeritus, was the first special advisor to the UN Secretary General on the prevention of genocide, and currently serves as the UN Special Rapporteur on torture. But how did he get there? And it wasn't just the trips to the pumpkin patch that we were talking about a moment ago. So, as part of a series of events that we do from time to time, we ask noted human rights figures to come and talk about why they do the work they do, how they got to where they are today, because there's so much that we can learn from everyone's personal story. So I am honored and privileged that he has agreed to do that today, and I want to introduce Professor Juan Mendez.
Thank you. Thanks very much for a lovely introduction, Hadar. Thank all of you for being here. It is a special privilege for me to speak to AU audiences, but to speak about my experiences is even more of an honor, particularly because some of you may know this, but I actually am an alum also of WCL. When I came out of Argentina and I was a lawyer there, I didn't know whether I wanted to go on being a lawyer or not, but the DC bar had a rule by which foreign lawyers who took some courses in an American accredited law school could take the bar, and I thought that was an opportunity that was hard to pass up. And I came to WCL to take those 24 credits and then become a member of the DC bar. And it was a great opportunity. I mean, those are the kinds of decisions that you take not knowing whether they are the right decisions, and they become the right decision much beyond your expectations. And I don't mean only because I became a member of the bar, obviously. It's because it gave me the chance to meet Professor Goldman, who was interim dean then. And when I had run completely out of money, they gave me some financial aid to continue studying. But also because of what I learned at WCL. And I learned a whole new way of teaching law from what I had been used to in Argentina and in the civil law system generally. But I also learned the value of trying to use the law for social justice and for human rights protection around the world from professors, some of them still here, some of them unfortunately gone, like Professor Bert Weschler, for example, who was my professor in a couple of courses. And I took evidence, which is not something that is taught in the civil law, from Professor Rice. So for all of those reasons, I'm very glad to be back at WCL. I am particularly pleased when I'm asked to talk about my experiences. How it all began, you know, I could say that I became a lawyer because when I was 15 it was clear that I was not going to be a soccer star, so I needed to find a profession. But beyond that, I actually, I was always in doubt about whether law was the most important avenue for me to develop some skills. But in Argentina in the late 60s, it was a time of such turmoil that lawyering became a political commitment as well as a professional skill. And I was a student leader in a small Catholic university at a time when these very hectic times were bringing together students and workers in challenging military dictatorships. And I studied through all of law school with a military government that was only a preview of what was going to come. The real criminal dictatorship is actually one that came later in 1976, came to Argentina. But I graduated in 1970, and having been a student leader, I almost immediately fell into doing criminal work. It wasn't my first choice, but I wanted to be a labor lawyer. But almost all of the young labor leaders that I tried to represent were also having political problems, and so I ended up doing a lot more criminal work than I thought I would do. And that actually helped me a lot later on when I became an international human rights lawyer, because I could understand matters of due process of law, and particularly the rights of criminal defendant and the workings of habeas corpus. I had to learn that the hard way when trying to use habeas corpus to protect somebody from being tortured. But it's amazing how the same principles apply everywhere else today. I mean, habeas corpus is, as you know by now an international principle, obviously inherited from the common law, but by no means restricted to common law countries. It's really an obligation of the state established by international human rights treaties. So knowing how it works in practice actually helped me a lot later on as well, although obviously I didn't know it at the time. I was arrested twice in Argentina, the first time for only a few days, but the second time the government that preceded the military dictatorship, the government of Isabel Perón, who had become the president after her husband, General Perón, had died, had established the state of emergency, or state of siege as it's called in the Argentine constitution, and that allowed the government to hold people without charges. And that's why the second time I spent 18 months in custody. Now I know it sounds strange, and it will sound even stranger to you to say that I was among the lucky ones, because at last count there are something like 120 lawyers among the disappeared of Argentina, and more than 100 who, like me, spent some time in custody without charges, and in most of those cases for longer periods than me, maybe an average of 3-4 years. And then there's some, maybe a dozen or so, murdered. Well-known lawyers who were murdered in the streets of Buenos Aires or killed in the torture chambers. So I just want to give you this sense of how lawyers became a target. I mean, actually General Videla, who fortunately is now serving at least 2 and maybe more coming life terms for his crimes, did say in a meeting with foreign correspondents that the subversives were not only the armed guerrillas, but he gave about 6 categories of other subversives, and the first in his list were lawyers. Lawyers who defended political prisoners, he said, obviously, not every lawyer. So, in a situation like that, this profession becomes risky, becomes complicated. And whether you continue doing the work in the face of trouble is really up to you. But if you really believe in justice and believe in law, it's very difficult to make the calculation that maybe I'll let somebody else do it. And obviously when you're doing it, you also think that it's not going to happen to you anyway. You are under the impression that yeah, well, this is a bad moment in the history of our nation, but it's not going to last long. In our case, it didn't last long. It lasted 6 or 7 years, but long enough to create a lot of problems for a lot of families and a lot of colleagues. So that's the part that brought me out of Argentina. I was very fortunate, again, that I had been a foreign exchange student in the United States when I was 16, 17, and the family that I had lived with in Iowa had remained in touch with me. And when they learned of my plight, they organized an incredible campaign on my behalf. They got Amnesty International to adopt me as a prisoner of conscience, but also they pestered their congressmen and their senators and everybody else who would listen to ask them to intervene on my behalf. And so at some point, the government of Argentina looked at their files and said, who is this guy, who gets so much attention? He's not that important to us, so in order to relieve a little bit of the pressure, they actually sent me out of the country. And I said send me out of the country because I was not released in Argentina. They literally escorted me to a plane and put me out of Argentina. But that was a lot better than what was happening to my colleagues and friends who were still in custody and, as I said, spent much longer than me in prisons. In the context of being arrested, I was tortured. We can talk a little more about it in the question and answer period. And I spent 18 months in administrative detention without charges. I was not among the disappeared, except for maybe the first 3 days or so of capture, but the actual campaign of disappearances began after my time, after I was arrested. And I was, again, lucky in that because of the small group of younger lawyers who were trying to continue to defend political prisoners. I was the first to be arrested. Because I was arrested at the time when the campaign of disappearances was not in place, I was tortured and held in administrative detention, but my life was spared. Of the small group of people who I was working with who were still defending political prisoners, maybe a dozen of us, no less than 7 are now counted among the disappeared, only because they were arrested 6 or 8 months or a year after me. So anyway, Amnesty adopts me. The government decides to get rid of me. They put me on a plane, and I came to the United. First, I went to Europe, but I didn't want to stay in Europe because there was all kinds of exile groups there, and I thought I was going to be a lot more useful in the United States with having lived here for a year and also having pretty good English, which not too many Argentines have. And so I decided to accept an invitation for that family that had hosted me as a foreign exchange student. Now they hosted me and my family, because by then I had 2 children and my wife. And we could start over with their help. And I lived in Illinois for about a year, and I worked in immigration issues, especially with Mexican immigrants and with the Catholic Church. But in order to be more effective for human rights in Argentina, I moved to Washington, and I worked in immigration issues there at a public interest law firm here in town called the Washington Lawyers Committee for Civil Rights Under Law. But I continue to do a lot of volunteer work for Amnesty, and then gradually for other organizations as well. And I was also at the right time and the right place when what is now Human Rights Watch was being founded, and they wanted to have an office in Washington and somebody with expertise on Latin America to launch their Americas division to go with their Helsinki division, which at that time dealt mostly with Eastern European issues. And so I opened the Office of Human Rights Watch in Washington in 1982, and gradually the organization grew, and I was very, very happy, very lucky to be able to participate with a group of really enlightened people who wanted to do international human rights work, wanted to follow in the path of Amnesty International, but also brought to international human rights a kind of expertise that they had developed in the fight for civil liberties and civil rights within the United States, and an ability to work with the media and the press that was unparalleled at the time. And that gave me the opportunity to do some novel things that were not part of the picture then, although now we're all familiar with them. But for example, how to do credible and sustainable fact-finding in conflict situations was something that I learned with Human Rights Watch, particularly in the Central American wars. We would travel to Nicaragua and El Salvador and Guatemala, and we developed a certain methodology for fact-finding. And the methodology, among other things, was developed because we were challenged. The Reagan administration particularly challenged us and wanted to say that our information and that of Amnesty was not reliable, that they knew better what was going on. And so we got into a very public fight in the editorial pages of different newspapers, but also in the news, about whose information was more reliable. And I have to say that we won hands down. I mean, we could demonstrate to the public of the United States that the Reagan administration had all kinds of reasons to misrepresent what was really happening in Central America. And that was an incredible experience, as you can see, because at the time human rights organizations did, of course, rely on their own information, but were very careful not to be identified with any kind of political motives, etc., and therefore did not, for example, reveal sources. And we, as long as we had the consent, of course, of our sources, we did reveal sources, and we tried to make our reports self-sustaining and credible to anybody who read them. And so we footnoted them, and we gave the source of the information that we had. And we wrote them in a way that engaged in the dialogue, in the kind of very public and very sometimes very contentious dialogue with the governments that we were dealing with, the Sandinista government, the Salvadorian governments, the Guatemalan government, but also with the administration and its views of human rights in each one of those states. And at the same time, because this was part of the foreign policy of the United States, and particularly military and security policy, they got a lot of attention in Congress. So we also pioneered, debating our reports in Congress and being able to sit there and ask and be asked questions about how we got our information and whether we stood by it and all that, which I think not only gave human rights reporting much more visibility, and of course with that comes effectiveness, but also helped us refine our methodology so that we were satisfied to ourselves that what we had gathered and what we were reporting on could withstand even the closest and hardest scrutiny. But of course, it also made our methodology of fact-finding on the ground a lot more rigorous as well, although over time we perfected it. Anyway, along those years, the organization grew much bigger, and my last years at Human Rights Watch, I was general counsel, now with responsibilities for the whole world, and particularly with applications of international law, campaigning and advocating for the creation of institutions like the International Criminal Court, and also for policy directives. We had to decide regularly and hopefully, methodically, on what position we would take, for example, with respect to the rights of gays and lesbians, or what position we would take with respect to women's rights, or with respect to economic, social, and cultural rights. And those were debates that were very rich and gratifying within the organization, but they were not easy. And they were not easy not because anybody was against any particular set of rights, but because we had in mind being as effective as we could be. That our main concern was to be able to offer to victims of human rights violations the best possible support and advocacy strategies. And for that you had to be selective, or at least you had to have the sense that what you did best is what you stuck for, and you incorporated new themes and new avenues only after careful thinking and going over what you actually could contribute. And as General Counsel, I had to learn a lot of international law, and quickly too. So I was very privileged. Among other things, for example, on that role, I met people like Richard Goldstone and Antonio Cassese, who unfortunately died only this week. He didn't. I can't say that I learned directly from him, but he did come to our offices and talk to us, and it was such an inspiration to have people like that running the most important new institutions of human rights protection and of international criminal justice, that those things have stayed with me all this time. I'm going chronologically, and I'm going to stop soon, but I left Human Rights Watch in the late 1990s, in 1996. I was for 3 years the director of the InterAmerican Institute on Human Rights in San Jose, Costa Rica, which is a kind of educational arm and research arm of the Inter-American Court and of the Inter-American Commission. And I had practiced before the Inter-American Court extensively. By the mid-90s, I had appeared many times before the court. That was part of the Human Rights Watch strategies as well, to use the instruments of human rights protection, especially those of state responsibilities, and that helped me learn a lot about this. But after 3 years with the Inter-American Institute, I decided to start teaching human rights and law full-time, and I was appointed professor of law and director of a center for human rights at Notre Dame Law School in South Bend, Indiana. And simultaneously with that, I was elected to the Inter-American Commission on Human Rights. And I served one term there. I wanted to serve another term, but I did not get elected, among other things because some countries that didn't like what I was doing sabotaged my re-election, which sometimes probably, or at least I satisfy myself to mean that maybe I was doing something right. Be that as it may, and I don't want to sound like just an extended resume, in 2004, I left academia again, and I became the president of the International Center for Transitional Justice, both at Human Rights Watch and later at the Inter-American Commission. And from teaching, I had spent a lot of time thinking about what states owe to the victims of mass atrocities, and I had written and published about it. And this organization was created, among other things, precisely to disseminate the best practices that were happening around the world on truth commissions, on prosecutions, on reparations to victims, on institutional reform, on memorialization of the victims of human rights abuse, etc. So that was also a very interesting new way, new frontier, if you will, of doing human rights work. And simultaneous with that, Kofi Annan appointed me his special advisor on the prevention of genocide, which I did part-time for about 3 years. Actually, I wasn't part-time. I had 2 jobs at the same time, working for ICTJ and being the special advisor, because the special advisor's job was new, but it was also very busy, very hard work, quite frankly. And we can talk about what prevention of genocide means in the context of the United Nations, if you're interested on it, at the question and answer period, which we're getting too close to it very soon, because since then, in 2009 I came to WCL. I'm a visiting professor here. I'm visiting more or less indefinitely, it seems, which pleases me no end, because I'm really happy to be here. And I was elected the Special Rapporteur on Torture. I'm almost completing my first year on that, and my term is for 3 years, renewable once. It's getting very busy. You know, some of you students have helped me with some of the topics that I've been working with, and Hadar and I are hoping that we will be able to organize ourselves to generate more interesting opportunities for students to help in the work of the rapporteurship. It's a very demanding job because the rapporteurship has been around for 26 years, and it has been held before me by 4 very prestigious European jurists. I'm the first non-European to hold it, and you know, I see it as an opportunity. It's obviously a challenge to follow in their footpaths, but it's also footsteps, but also a platform from where you can do a lot of very good work. And it's very much in demand. The victims of torture around the world use this mechanism very frequently. It has its limitations, of course, among other things, the fact that its rulings or decisions or recommendations are clearly not binding on states, so you have to use much more your powers of persuasion. But it also gives you a chance to work worldwide, because literally the rapporteurship has at least the possibility of working on 193 countries that are members of the United Nations. I've just presented my first report to the General Assembly, and I dedicated it to the issue of solitary confinement. And I didn't know at the time how good a choice that was, because it has gotten much more attention than I had expected. And I also hit on an issue that, on the one hand, is growing in its use, it's expanding, it's being used for many different purposes, and not all of them reasonable or legitimate. But it's also one that doesn't have very clear standards. And so that part of the role of the rapporteurship, to generate a discussion about standards, is something that clearly the office offers us a great opportunity. So I'm hoping that my report will generate a discussion about standards about solitary confinement. When and under what conditions it's so severe that it turns into cruel, inhuman, and degrading treatment, or even worse, it turns into torture. And what the states should do in order to prevent that line from being crossed. Because there's undoubtedly some areas in which solitary confinement is legitimate. But those are areas that even now don't have clear safeguards that states are supposed to put in place, so that the pain and suffering that is inflicted doesn't become torture or cruel, inhuman, and degrading treatment. So it's a very encouraging sign that I got a lot of comments on it and requests for press appearances and the like. I'm hoping that it'll have a little bit of a shelf life, and you know, that also, of course, will depend a lot on the way civil society deals with the report. I think I'll stop here and let you ask me questions, because otherwise this is going to be too much of a monologue. But again, I really appreciate your attention and your coming out today to hear me speak. Thank you.
This is meant to be a conversation, and so please come to the microphones. You might need to click it on. Please
Hello.
Introduce yourself.
My name is Marino Castilla. I'm an LLM student here, focusing on human rights. And my question is, basically you mentioned that when you were young, you were very active in, you were a student leader, and you were very active in the political dilemma that was happening back in your country. How much did you being imprisoned by those same ideals contribute to your drive in the human rights? Or maybe do you think you would have achieved everything that you have achieved and in the fight for human rights if you had not gone through that experience? Thank you.
Well, thank you. Yeah, the degree to which it still influences what I do is something that I've thought about too, and I just don't have a very clear answer. So much I thought about it that I thought of writing a book about my experiences, and it has been published. In fact, Dean Grossman is holding a book reception this afternoon on it. He's very, very kind to help me with it. I think it works in many different ways. I mean, obviously, once you've been in prison and you've been tortured and you've seen your friends being tortured, and in my case, in some cases, being killed, taken literally out of my cell block and shot, those are things that you don't abandon anytime soon, and you don't want to walk away from. You feel a responsibility and all that. So in the first few years, the dictatorship was still raging in Argentina. So I felt that I had the responsibility to try to get people out of prison, to try to help the relatives of the disappeared. So at first it was very much kind of a demand of conscience, if you will. But I had the incredible good fortune that what I was doing on a volunteer basis, there soon appeared opportunities to do it on a professional basis. And I have to say that the fact that I had been adopted by Amnesty, that I had been in prison myself, that I had some lawyerly skills that could be useful in Latin America particularly, became, kind of a very favorable thing to put in your resume. So I am, very certain that it helped a lot. You have to think also that 30 years ago, when this was happening, the jobs in human rights were much scarcer than they are now. But there was also much less interest, and so the competition was much less fierce than it is now for human rights jobs. So in a way, what had happened to me was, clearly offered me professional opportunities, but I also, of course, wanted to do these things, and that I could do them while at the same time raising a family and living a relatively decent life without getting too much burdened in debt was also a great opportunity. Yeah.
My question is the following. Do you think that the political environment or the political context in a specific period can affect the work of human rights defender or special rapporteur when they are going to adopt certain position? I am asking you because you know that we are now in the context of the war on terror, and many decisions that are adopted by NGOs or human advocates are considered to be like based on political bias and sometimes are criticized. And what do you think about it? Do you think that that can influence the way how human rights defenders can adopt certain positions?
Well, I think it's useless to say that human rights advocacy is should be completely free from politics. I mean, human rights are realized in the context of policy choices that all nations have to make, and the human rights defender is a citizen. He or she has to be allowed to have political opinions. And so the fact that human rights defenders against right-wing dictatorships tend to be more sympathetic with left-wing causes, and vice versa, I should say, doesn't mean that they're not legitimate human rights defenders. And I've always, fought that attitude that unless you are pristine and absolutely free of any kind of political entanglements, then you're not credible. What's credible is what you do and what you say, what you found out and how you found it out. I think it's very important for conversely, for human rights defenders to admit what their political affiliations may be, and also to be very rigorous with the advocacy positions that they take, so that their political motivations may be transparent and it will still not affect the credibility of their work. For that, I think human rights organizations and human rights defenders have also to come up with their own way of doing things, and to be ready to defend the rights even of those people who they don't agree with. I mean, that's something that's very hard to do in the middle of confrontation. It's very hard to do, and I recognize that if I had been asked when I was just fresh out of law school in Argentina to defend the rights of some of the right-wing groups that were attacking me, I would have shrugged it off, and I would have said that was not part of my political contribution to political change in Argentina. But over the years, and especially working on a variety of countries, you come to realize that human rights standards are universal in every sense of the word. They're also ideologically universal, and that even your worst enemy deserves some kind of rights, and that you have to be willing to defend it on principle, not necessarily spending all your time on them, but defending the principle that nobody should be tortured, that nobody should be arrested without due process, that nobody should be held indefinitely in detention without trial. Now, in respect to the war on terror, what happens is that many countries, including very well-established democracies, come up with ideas about the exceptional situation in which they're faced, and that therefore more or less that warrants abandoning certain principles, and or at least the application of certain principles to some situations. Now, I have to say that it's very disappointing that some of those arguments are the same arguments that dictatorships make. But also we have to bear in mind that the political context makes a lot of difference. If you are in a democracy, even if policies are wrong, you always have the chance to fight back and to organize and to defend principle. And that is something that that is priceless, quite frankly, that we should always defend. Not so much to say that democracies don't commit human rights violations. Unfortunately, history shows that they do. But democracies do give us a situation, a moment, a scenario in which it is much more possible for all of us to defend human rights than in a dictatorship of any sort. Sorry, go ahead.
Hi, I'm Jeff Lubbers from the faculty here, and it's really an admirable career, and
Thank you,
it's
Jeff.
also, your story is also a very positive commentary on the worth of student exchange programs,
Yes.
which I really support. Years ago, I read a book about the Argentine situation called Imagining Argentina.
Yes.
I can't remember the author's name, but
It's Lawrence Thornton.
it was a great book that
Yeah.
really, was very profound about the plight of the disappeared. I recommend it to people. And I guess I have two questions for you. One is, it looks like, I guess I'm asking, Argentina seems to have pretty much come out of that situation quite well. And just this week, I guess there was an election in which the president got 53% of the vote and so forth. And so my one question is, when you look at Argentina today, what is your view? And I have almost the exact same question about when you look at China today, what is your view? Because obviously there's some human rights abuses in China, lots of them, but also the Chinese government has been able to pull a lot of people millions of people out of poverty in the last 20 years at the same time. So I'm curious about your reactions to both of those situations.
Okay. Yeah, Imagining Argentina was turned into a movie as well. Unfortunately, it had a very, very short run. I think, nobody saw it anyway. But it is possible to find it. I think it's with Antonio Banderas, for those of you who follow heartthrobs. It's fiction, and it's a very interesting kind of fiction because it deals with the problem of the disappeared, and the political context is well described, etc. But you should read it anyway. But I think it's one of the best works of fiction about Argentina that has been published after the campaign of disappearances. Now, I am, even with or without this election, I am very pleased that Argentina has come through. We've had more years of stability in democracy than we've had in our whole history. Can you imagine? Well, that's not saying much, because Argentina was never very stable. But since 1983, we had a succession of democratic governments of different political orientations, and we've had incredible economic crises, more than one, along those years. But nobody called for a suspension of the constitutional order. Nobody went knocking at the military headquarters doors asking for the military to take over, etc. And I think the reason for it is because at the end of the dictatorship, the government, the society, and especially led by the human rights groups, but also gradually the state, decided to reckon with the legacy of human rights abuses in a very comprehensive and wholesome way. And so Argentina pioneered truth commissions, pioneered prosecutions of the highest ranking officials. We went back, but then we started again. And right now, Argentina and Chile are the two countries where more prosecutions and more people convicted for human rights abuses can be found anywhere in the world. And I was just reading last night precisely results of the election, and particularly results of opinion polls. And it's interesting that the issue of among 10, where more people agree that even across party lines, is on the trials of the dictatorship, of the crimes of the dictatorship. 80% of the population is in favor of the trials. So it's no longer that this government wants to push the trials. I mean, of course, the defendants say that, but it's not like that. Even among the opposition parties, the rate goes to 80%, something like 80%. In the winning parties, like 93%. But the average is more than 80%, and it's, you know, if you compare it with economic policies, with citizen security, those kinds of issues, that there's such degree of agreement among everybody in Argentina is really spectacular. And the courts have taken it upon themselves to say, this is public policy. It's not it's not owned by any particular party or any particular ideology. Is what we have to do because this is our idea of justice. I am very gratified about the election, not so much because the party that I sympathize with has won. I do favor the president, but obviously this is not a perfect government. It has many mistakes, many things that are worse than mistakes. But one thing that it is very good, and it also a part of its success is luck. I mean, Argentina now has very good international prices and excellent crops. But part of it is good stewardship and good management, and particularly saying, well, if we're having all this influx of money, let's make sure that we start redistributing, that we don't just bend to the whims of the banking sectors and everybody else, but within reason and not jeopardizing economic growth, but we start distributing and we start favoring the pensioners, for example, and the poorest of the poor. Argentina still has a very serious problem with poverty, especially for the history of the country. It used to be a much richer and much more evenly distributed society. It was the most evenly distributed, together with Uruguay, of all of the Americas. Now it's lost considerable ground, but it's recovering, and the government is popular because it is seen as giving priority to those things. And I think that's very, very good. And let's hope that the favorable winds continue. I mean, it's difficult to know. We're certainly not protected from a worldwide economic crisis, but I think all of Latin America is at least in a relatively better position to defend each country from a worldwide economic crisis if it happens. Now, with respect to China, I also recognize, how couldn't I, the immense progress that China has made in its economy and in lifting people out of poverty and creating even a middle class, etc. I just don't think that that justifies some of the authoritarian tendencies of a single party government that where some leaders assign for themselves the right to tell people what they can read, what they cannot read, how they can organize, whether they can have trade unions and things like that. I just never bought the argument, even with poorer countries, that in order to have economic and social development, you needed to have to restrict civil and political rights. I think both have to go together, and when they go together, the results are much better for all concerned. I mean, there are countries that have, made incredible strides in the welfare of the population, and they have not restricted, say, freedom of speech, freedom of expression. I just think that if we really believe that all rights are interdependent and interconnected, then I think it's important for us to continue to hail China for the great progress that it's making in economic, social development, and I would say in some areas of civil and political rights as well. I mean, I'm not denying that some of it is happening as well. But also say, it's still no reason for you not to respect a universal right to free expression, to political organizing, to real competitive elections, etc. Yes. Sorry that my answers are a little long-winded.
I was kind of wondering what you think about the situation with Bradley Manning right now.
Okay. Well, as you know, Bradley Manning is the U.S. soldier who is accused of being the source of the leak to WikiLeaks of a huge cache of email messages that has been circulating since last year. He was arrested in Iraq and then brought to Quantico here in Virginia, and is now in Fort Leavenworth. When he was in Quantico, his lawyer and his friends claimed that he was being held in solitary confinement. And in that context, they wrote to me and asked to engage the United States government on his case, which I did in late December, and then I had a series of conversations with the State Department and with the Defense Department, the Pentagon, on his case and several others, but his case got a lot of visibility, obviously. This exchange is over by now, but I have not yet published the end result of the engagement. So I am writing my conclusions of the matter. So I can't, because I have to send them to the government. I can't, be more specific about what I'm going to say. But I do want to say that in April, when he was moved to Fort Leavenworth, he was no longer put in solitary confinement. And as far as I know, he has not been in solitary confinement in his present conditions of detention. Now, obviously, as you can imagine, I don't get involved on whether he should be in prison at all or not, or whether he should be tried or not. Those are things that are outside my mandate. But solitary confinement is clearly within my mandate, and the Pentagon claimed that it wasn't solitary confinement, that it was something else. They have several, well, in the Marine brigs, as they call them, the prisons, they have a regulation that has several different regimens of detention. And what they claim is that he was in a regimen that they called prevention of harm. They didn't give much reason as to what harm and to whom they were referring to, among other things for privacy reasons. But they said that they do have solitary confinement, but that was not what he was subjected to. So that in part hinged on, understanding, what is solitary confinement to me may be something else for you. So I actually inquired exactly what his daily regimen was. And indeed, he was being held for 23 hours alone in his cell, and he was given 1 hour of exercise. So even that exercise was by himself, so he didn't have social contact with others. And so the only people he actually saw in those 24 hours were his jailers. And, but he did have access to 1 or 2 hours of radio or television, I believe. He could write letters home and receive letters. I think he could read newspapers and magazines, I'm not sure of that. And of course he had visits from family and from his counsel. So still he spent like 8 months in those conditions until he was moved to Fort Leavenworth. So the issue is whether that crosses the line that I mentioned between legitimate uses of solitary confinement and what constitutes cruel, inhuman, and degrading treatment. And then part of the engagement with the government was why and by whose decision he was held in there. And the Pentagon told me that the decision is solely up to the brig commander, the chief of the specific prison, and that the reasons had to, under the regulations, had to do, as I said, prevention of harm, but also linked to the gravity of the crime that he was accused of committing, which in my mind should not be a valid reason. I mean, he's still innocent. I mean, he still enjoys a presumption of innocence. He has not been court-martialed yet. He has not been found guilty of any crime. So the relationship between the eventual crime for which he can be convicted of and the form of punishment, the actual conditions of detention, should have nothing to do with it. That's my suggestion. And in fact, that's one of the things that I'm saying in this general report on solitary confinement, that if it is as a penalty, and worse, if it is in pretrial detention in relation to a potential penalty, those things should be unacceptable.
Hello, I'm Yakov, I'm a 1L here. And you had mentioned how part of your investigation was on whether the actual conditions he was in constituted solitary confinement. To that extent, it seems that a lot of the modern, at least the modern Western discourse on torture has shifted more to definitional arguments towards the inclusion of some items and not others. And that, for example, when President Clinton was considering whether torture was ever permissible in cases of emergency, that was specifically on the use of torture in general and not on whether some things constituted torture and other things haven't. So do you feel that that question on whether or not torture was ever permissible is still on the table? Or do you feel that the modern discourse is solely on what does and doesn't constitute torture?
No, I think the question of whether torture is on the table the answer is no. But I have to say that that's not new, because even when the Bush administration, wrote the infamous torture memos, they were not denying that torture was prohibited. They were just redefining torture in a different way so as to avoid the label. So in a way, it's a recognition that that torture was impermissible. The redefinition itself is a way of torturing language, if you will. Among other things. But even then, when those memos were revealed to the public, they were withdrawn, even by the Bush administration. So it's almost a recognition that they were wrong on the law and wrong on the facts, and that they were permitting practices that under any reasonable, any serious, any good faith interpretation constitute torture, like waterboarding, for example. So, but the problem with solitary confinement is that the Torture Convention and international law on torture generally, because it's also customary law, all it says is that any kind of pain and suffering, whether mental or physical, that constitutes a certain level of cruelty or cruel, inhuman, or degrading treatment or punishment, or constitutes torture, is prohibited. But when any kind of treatment reaches that level of severity is difficult to ascertain because it depends on both objective and subjective conditions. In other words, for example, pushing someone around who is a 35-year-old healthy male may not constitute even cruel, inhuman, and degrading treatment. But if you do the same, exactly the same thing to an infirm old lady of 85, you know, even just one shove can be torture. So that's what I'm saying, that it depends a little bit on subjective conditions, but also on objective conditions. And so solitary confinement, all we know is that if solitary confinement creates a kind of cruel, inhuman, and degrading, the pain and suffering associated with cruel, inhuman, and degrading treatment, or at a higher level with torture, it's forbidden. But when or how or in what circumstances it does is difficult to say, because there's all kinds of features of solitary confinement, all kinds of different uses for solitary confinement that that are not clearly standardized. There's no uniform standards. I mean, in my presentation at the General Assembly, the intervention of the U.S. government started by saying, well, it's clear there are no international standards. And I said, yes, that's right, and that's why I feel that we need to come up with some standards. We need to debate and discuss what those standards are, because the prohibition on torture and on cruel, inhuman, and degrading treatment is there, and it clearly refers to mental suffering, not only physical. So, and that's why I call, among other things, for a complete ban on prolonged solitary confinement, you know, and however defined. I use the line of 15 days, but you know, you could do it a little higher or a little lower, but prolonged solitary confinement, and particularly indefinite solitary confinement, because that from day one adds a level of uncertainty and anxiety to your psychiatric well-being that itself can constitute torture. Incidentally, after I wrote my report, because it would have been great to cite it, but I was alerted that Charles Dickens, back in 1835, I believe, visited U.S. prisons at the time when solitary confinement was a feature of U.S. prisons, and it was a benevolent one. The Quakers actually believed that you needed to keep prisoners separate and from each other. And he said that it's a kind of psychiatric, mental suffering that undoubtedly constitutes torture. And of course he said it in much more literary, memorable ways than I have just said it. Interestingly, the U.S. invented solitary confinement, and by the late 1800s had abandoned it because it was seen as absolutely cruel and unusual punishment under the U.S. Constitution. The Supreme Court actually banned it, I think, in 1890 or so. And it has made a roaring comeback. It's come back in the last 30 years. It's used everywhere, in every state prison, in every federal prison. It's used in the war on terror. It's used for disciplinary breaches. It's used for prison management. It's used in immigration detention. It's really amazing. And many people from the corrections profession feel that it is cruel and that it's useless, that it doesn't help at all, that it actually makes matters worse. But there are some corrections officials, obviously, that defend it. But more than anything, it plays to the public. You know, the public. It's very easy to get elected to any kind of electoral position in this country by acting tough on crime. And if you say you elevate the penalties, but then you also add solitary confinement and you build prisons to have solitary confinement and all that, you're guaranteed re-election all the time. And many prison officials will tell you, we don't want this, but, if the legislature wants us to build and manage and run prisons like this, we have to. I'm hoping that, my report is simply a contribution from international law. But I'm hoping that it will generate some contribution from people, in criminal justice reform, in corrections, and especially, I think, literature from the medical and psychiatric establishments, because it is pretty clear that solitary confinement creates a kind of pain and suffering that, there's no other way to look at it but torture or cruelly inhuman and degrading treatment. Well, thanks very much for being here and for asking such wonderful questions. Thank you.